Hello, everybody. Welcome to our community legal education on renting during COVID-19. I'm Sophie from Canberra Community Law, and we've got Bryce here as well, a tenancy lawyer from Legal Aid. So we're Zooming you from Canberra, Ngunnawal land, and we'd like to start by acknowledging the elders, past, present, and emerging. We pay our respects to the traditional owners of the land, and we acknowledge that sovereignty was never ceded. We wanted to host this session this evening because both Legal Aid and Canberra Community Law have been getting lots of questions from the community about what COVID-19 means for renters. There have been plenty of announcements about the impacts of COVID-19 on renters. There was an announcement about a moratorium. Oh, apparently it's frozen on Bryce's face. That's good to know. Hold on, let me see if I can fix that. Okay, I think we're good again. So there have been plenty of announcements so far from Scott Morrison about a rental moratorium, from the ACT Chief Minister Andrew Barr about something similar, and it just might be a bit confusing for folks exactly what all of these changes mean. So I know that people, for some people, this will be the first time that they've been without employment. They might have lost shifts, or perhaps because of some of the other restrictions, you might have seen a downturn in your business, or for some other reason be experiencing financial hardship. And one of the first things to go sometimes can be rent. So we wanted to talk through what all of this might mean for you, what help you can get, and what are your rights and responsibilities during COVID-19. So the standard disclaimer is that this session is about legal information. It's not specific legal advice for your circumstances. So please post questions in the comments about renting, about any concerns that you have. But if you need specific advice about your specific circumstances, Canberra Community Law will post in the comments now the links and information to contact Legal Aid, where you can get private tenancy advice, or for Canberra Community Law, where one of our social security and tenancy lawyers can talk you through your rights and responsibilities if you're living in ACT housing or community housing. So to kick us off, I might hand over to you, Bryce, to give us a bit of a rundown on the changes announced by the ACT government for renters during COVID-19.
Yes, thanks, Sophie. Good evening, everyone. Bryce, I'm with Legal Aid ACT. So the ACT government has taken a few steps in response to the COVID-19 pandemic and the impact that it has had on the tenancy landscape as well as the employment landscape as well. The first thing to point out is the COVID-19 declaration that was made, and that was made on the 22nd of April, 2020. That declaration was mainly targeted at securing housing for people who are already in tenancies and are at risk of losing their tenancy due to an impact on their household income, whether that be to losing their job, whether that be to becoming ill with COVID-19. And I think an important thing to remember is that this applies to all residential tenancies, private or public. Unfortunately, a lot of these protections don't apply to occupancies. So a lot of what I talk about and what we talk about tonight will mainly be about tenancy agreements and not occupancy agreements. One of the big questions we've been getting asked at Legal Aid is, do I still have to pay rent? And unfortunately, right now, the answer is yes. There's nothing in place that is requiring mandatory rent reductions. The declaration has drafted a template clause that tenants and lessors can agree to include into their residential tenancy agreement, and that will provide a genuine rental reduction into the tenancy agreement that a tenant does not have to pay back later. However, at the end of the day, the landlord does have the final say on whether or not a rent reduction takes place. And so if a tenant is unsuccessful in negotiating a rent reduction with their landlord, their full rent is still owed. And if they can't pay it during the moratorium period, their landlord may be able to pursue it as rental arrears as a debt toward them in the future. The positive side to this is that there is a ban on evictions for people in impacted households. So even if you can't pay your rent, and it may be a bit of a difficult task in the future, you can feel a bit safe knowing that you won't be losing the roof over your head during the moratorium period. This moratorium period right now is only about 3 months long until it's 22nd of July. But within the declaration, they've given themselves the ability to extend it another 3 months if necessary. So I mentioned impacted households. One of the big questions we get at Legal Aid on the Tenancy Advice Service is, what is an impacted household? Do I qualify? So to be an impacted household, there's two criteria or two main prongs. The first is that if any member of your household has qualified for job seeker or job keeper since March 2020. And the other prong is if your household's income has dropped by 25% due to a rent-paying household member being impacted by the COVID-19 crisis. And again, that can be due to someone falling ill, someone caring for someone who's fallen ill with COVID-19, or someone who's just lost their job due to the lockdown laws that have come into effect. And outside of the declaration, there have been some other steps taken in the tenancy space that I think are going to help tenants in this time. We do get a number of calls from people who are in periodic tenancies, and they are having landlords pressuring them to sign new fixed terms or threatening to move back into the property. Under the old legislation, there was a 4-week notice period that a landlord had to give to a tenant with a genuine intention to move back into the property before terminating the lease. That has now been extended to 8 weeks. So if you're on a periodic tenancy, and if your landlord is starting to talk about maybe moving back into the property, just know that they have to give you at least 8 weeks notice of terminating the lease if they intend to do that. And another one that's really important for tonight's discussion as well, involving private and public housing, is that if a tenant in a private tenancy agreement, even a fixed term agreement, is looking to terminate their lease because they have been accepted into social housing, there's no penalties for doing that, and the notice period has basically been waived. So they made it a lot easier for someone who's struggling financially in a significant way to be able to switch into public housing without having to suffer any penalties. And I think Sophie might join me and talk a little bit more about some of the other elements that have come into play.
Yeah, great. Thanks, Bryce. So the declaration applies to all tenants in the ACT, public and private. And so there are a few more things covered that are relevant to all types of tenants. One that keeps coming up on social media as well as in our sort of formal advice line is around house inspections. Do you have to let your landlord into your house to do an inspection during COVID-19 when we're all being encouraged to socially isolate, to not be associating with people and being in close contact with lots of people? So the answer to that is, so basically the law generally, so not in COVID-19 times, says that the landlord may come and inspect your home 2 times in any 12-month period, with an additional inspection in the first month of a new tenancy and one within the last month at the end of a tenancy. But during COVID-19, these rules have changed, basically in recognition of the fact that for public health reasons, we're trying to limit our exposure to different people. And so the landlord, so if it's a public housing tenant, that'll be your housing manager through Housing ACT. And if it's a private rental, it might be someone from the real estate or it might be the landlord themselves. They can only access your home if you give them written consent. So if you write something down saying that they can come in, if they have an order from the tribunal that allows them to do so. So that's a whole process where they have to go to ACAT to get that order, or if they need to complete urgent repairs. So that might be something like a pipe has burst, or there's a reason why your house is unsafe and so needs to be rectified. That doesn't mean though that you just get out of housing inspections. They're still allowed to conduct an inspection, they just can't do it in person. So the way that they probably will want to do that is to do it electronically. So that could be through a video call. So perhaps your landlord or housing manager will call you, with FaceTime or some other video call and you can walk around the home and show them the various state that the house is in. You may have a conversation with them and agree that you'll provide photos. So that would require you to go take photos of the parts of the house that they've requested. And this arrangement, so this new way of doing inspections and the ban on landlords insisting that they come and do a in-person inspection, that's going to last for that moratorium period that Bryce mentioned. So that's until the 22nd of July. It is important to note, though, that you're required to provide reasonable cooperation with your landlord for them to be able to do this, form of electronic house inspection. So it's not enough for them not to be able to come into your home and to request that you do a FaceTime call with them so that they can have a look around on the camera, and you just refuse to pick up their call. That's not allowed either. So you do have to cooperate, but they can't just come into your home unless you provide them with written consent to do so. So that's the first one. The second thing that I thought we would touch on is repairs, because again, it falls into that category of having people come into your home during a time when that's largely been discouraged. So as within the non-COVID times, your landlord has a responsibility to keep your house in a reasonable state of repair. That's what the law says, and that's for both public housing tenants and for private rentals. There's a whole bunch of law around what a reasonable state of repair means, and that's based on the condition of the house when you first moved in. But for the purposes of us chatting through what's changed with COVID today, the big changes around what's called standard repairs and what are called urgent repairs. So a standard repair is by definition not urgent. So it's something like, say, one of the doors in your kitchen, like of a cupboard, has come off, or maybe an internal door in your house, or bedroom door or a living room door has become broken, but there's no safety concern. There's no way that, external people can enter your home. All the things are sort of functioning that they need to, but at some point someone needs to fix that damage. That's a standard repair. It is your landlord's responsibility to fix that. And normally the law says that your landlord needs to do that 4 weeks from the date that you let them know that that repair needs to happen. This has changed due to the coronavirus, and now the ACT government has approved some changes in the declaration that say the landlord needs to complete those non-urgent repairs within a reasonable time period. So that's not super clear, but basically the sorts of things that need to be considered is how much access into the property needs to happen in order for that repair to take place. So basically, how easy is it for that repair to be done? What's the hardship to you if it's not fixed? So for example, if it's a bedroom door, that would mean that you can't have any privacy in your bedroom. That's obviously the hardship you'd experience is a bit higher from that than, say, a small broken door on a kitchen cupboard, for example. So the landlord needs to consider these things and then come to an agreement with you, the tenant, and your landlord about when they're going to complete that repair. There's also a bunch of recommendations that the ACT government has made that you can rely on as well as a tenant about the way in which these repairs should take place. So the person coming into your home to fix whatever the damaged item is should be practicing proper physical distancing and observing good hygiene and doing all those things as well. The other category of repair is an urgent repair. So this is something maybe that presents a safety risk to you or the other people in your home. It could be something like a burst pipe, or maybe there's damage to your ceiling and water is coming in your home, so you're getting flooding. A gas or an electricity failure, a broken toilet. Any of these things are urgent repairs because you're either unsafe or you can't live comfortably and properly in your house with this damage. So the law says that your landlord is required to make urgent repairs as soon as necessary once you tell them about the problem. And this hasn't changed with the COVID-19. So if, for example, you have a broken toilet, you can contact your landlord and expect them to act on that immediately. So with public housing tenants, normally that takes place within 24 hours. It might take place in a shorter time frame as well. So if they don't do the repairs, your landlord or housing ACT, then the steps you would take are the same as what you would take in a non-coronavirus context. So the first thing to do is obviously to raise it. then there's a something called a notice to remedy, which is like a letter that you can write to your landlord or to Housing ACT. And finally, if those actions aren't taken, you can go to the Tribunal, ACAT, and apply for orders to say that your landlord needs to complete those repairs. But I think you can obviously seek legal advice to do those things. You don't have to, but you can from Legal Aid or from Canberra Community Law. But one really important point is sometimes people get frustrated when repairs take a long time to be completed, to be remedied. And I think this is particularly the case with standard repairs. And maybe during coronavirus, this will get a little worse because there is some more flexibility that the landlord has. And sometimes when people get really frustrated, they withhold rent because they think that's one way to pressure the landlord into taking action. That is not lawful. You cannot withhold rent to try to apply pressure for your landlord to do repairs. And in fact, what that means is that they can then use that, the fact that you're not paying rent, to try to evict you. Because as we discussed before, there is no blanket ban on evicting people just because we're in the middle of this coronavirus crisis. So don't withhold rent. Do report repairs that you need, whether they're urgent or otherwise, as soon as possible to your landlord. Remember that with non-urgent repairs, so things like internal doors or small amounts of damage, your landlord needs to negotiate with you a reasonable time to have those things repaired. If it's an urgent repair, so a burst pipe, broken toilet, anything like that, then they need to do the repair as soon as necessary. So I think what we'll do now is just talk through a couple of key big areas that are coming up for both private and public tenants. And Bryce and I will just talk separately about the ways in which they impact differently on private and public tenants. And then I can see that some questions are coming in on Facebook. So then we'll move on to answer those questions for you. So I might hand over to Bryce to talk to us about what happens when you can't afford to pay rent. So if something's happened and you've lost your job or you've lost shifts and you actually just can't physically pay the rent to your landlord, what should you do as a private tenant during this time?
Yeah, that's a really good question, Sophie, and it's one that we get a lot. The first step that we advise tenants to do is talk to their landlord and let them know what's going on. I think a lot of tenants call us out of a place of fear, and I think that's justifiable given the hardship that they're going through and given some of the stories that we're hearing about the negotiations between tenants and landlords in the news these days. But the first step is really always to reach out to your lessor or their agent and just let them know that things are going rough, that the pandemic is hitting you hard, and that you'd really love it if there could be some rental reduction built into the agreement to help you see through this time. What people shouldn't do is basically what you just advised, which is stop paying rent without any kind of communication around that. Because if you just stop paying rent, your lessor or their agent's just going to think that you're refusing to pay rent for maybe an arbitrary reason. But if you do put it out there that you're suffering some hardship, you never know what response you might get. You can also let your landlord know that if they're a bit iffy on entering into negotiations with you, that the ACT government has implemented a land tax rebate scheme for landlords who do offer genuine rent reductions to their tenants. It can be a bit complicated, but in its essence, if a lessor offers their tenant at least a 25% rent reduction per week, they can get half of that back in a land tax rebate up to $100 per week. So for example, if you're paying $400 per week for rent and your lessor gives you $200 off per week as a genuine rental reduction due to the hardship you're dealing with, they can go to the ACT government and get $100 of that back. So while it's not an enforcement mechanism that pushes landlords into giving rental reductions, it's meant to operate more as a carrot to hopefully entice them to do the right thing, which is look out for their tenants and look out for everyone in the community at this difficult time. And is it the same situation with you, Sophie? And I guess not in public. Public's a bit different in that sense. Yeah, but we also have been hearing some pretty bad situations of landlords requesting inappropriate information, I think, when tenants have been reaching out and requesting these rent reductions, they've been met with, I guess, distrust or a bit of stonewalling They've been asked for some pretty intense and in-depth information about their livelihoods, including bank statements. I think there's even requests made around superannuation, proving that they've attempted to withdraw on their super. And I think tenants, something they should know is that landlords, there is a fine line. Landlords aren't qualified to give advice around superannuation and whether or not someone can access their super or whether or not it's beneficial to them. So in that sense, if someone is bringing up superannuation, if a lessor or their agent is encouraging you to access your super, you can report that to the Australian Securities Commission, because it could be a violation of the law that they should be investigated for. But you shouldn't have to prove all of that stuff when you're asking for a rental reduction. Unfortunately, as I did say, there's nothing requiring landlords to give rental reductions. There's no law pushing them into it. And so really the amount of information you give is really going to be a level of personal comfort for you. We think reasonable evidence of hardship can be something as simple as a statutory declaration, discussing what you're going through, maybe a letter from your former employer saying that they had to stand you down, something to that effect. We don't think it's reasonable to be asking for anything beyond that.
Yeah, great. Thanks, Bryce. And so a stat deck, people can just download that from the internet, can't they, and just fill it in themselves?
Definitely. There's lots of deck templates out there that can be accessed by the public, that can be used. And if anyone's having difficulty with those, they can contact Legal Aid, or I'm sure they can contact Canberra Community Law as well, and assistance filling those out.
Yeah, great. And just a reminder for folks that we posted the contact details for Legal Aid and for Canberra Community Law in the comments. So if you do have any specific questions that you've thought of listening to this CLE, or you do want to get help, you can contact either of our organisations for that help. I might just jump in here and just because there are some differences between public housing and private housing with respect to rent reductions. So Bryce has talked about, as a private tenant, how you can go to your landlord and request a rent reduction, but evidently they're not obliged to give that to you. The case for public housing tenants is a little bit different, because the rent that you pay is calculated as a percentage of your income already. So if you're earning, let's say, $200 a week, your rent is 25% of that. It's a quarter. So you'd be paying $50 of rent. This applies whether it's social security income that you have or whether it's income from a job. The one exception to that is the coronavirus supplement. So that extra bit of money on top of the job seeker payment or some of the other social security benefits. That extra bit of money doesn't factor into that equation. It's 25% of your social security income, not including the supplement, or 25% of your income from whatever work you're doing. So if you end up in a situation where, notwithstanding any of that, you've been paying your rent in your public housing tenancy, and something has changed in your life. So maybe you're a student and you've been working part-time at the uni bar and using, a combination of Centrelink and that part-time job to pay your rent, and all of a sudden you lose your shifts at the bar and you can't pay your rent. What you need to do is contact Housing ACT straight away. You can find a form online called Rental Rebate Housing ACT. We can post it in the comments, but Housing ACT will also be able to provide it to you. And you basically need to fill in a new rental rebate form. The rebate is the way in which housing calculates that percentage of how much of the market value. So the house is worth a certain amount of money, you earn a certain amount of money, and how they reduce your incomes to come up with your rent. So if you have a change of circumstances, just like if you have a change of circumstances with Centrelink, you need to let them know, fill in a rental rebate form, and then they'll recalculate the rent for you. So as we said before, and it's the same for public and private tenants, when you just don't pay rent, you accrue rental arrears. So that means that you have a debt to the landlord. Nothing in the declaration changes this for private or public housing tenants. If you don't pay your rent, you're still in a situation where you're accruing rental arrears. So if you're a public housing tenant, and I should also say there's nothing in the declaration that prevents Housing ACT from evicting a public housing tenant. So what's really important is that before you start tracking up rental arrears, you tell Housing ACT about what your financial circumstances are, you apply for a rental rebate change, and they should talk you through that so that you avoid a situation where you're potentially accruing arrears and getting yourself into trouble. The other service that's available for both public housing tenants and private tenants is Care Financial Counselling. And you can find them online as well at carefcs.org. We'll post that in the comments too. They're a free financial counselling service, and they can help you with things like drawing up a budget and working out, in these really difficult changing times, how you can navigate the sort of financial troubles and changes that you might be experiencing. That's also something that may be useful if you choose to show to a landlord or to Housing ACT to demonstrate the kind of financial situation you're in. But again, as Bryce said, you're under no obligation to provide that kind of information. So that is the sort of rent reduction side of things. What happens if you can't pay rent? I think the final sort of big area is around evictions. So at the beginning, Bryce talked through what those major changes were that had been set out in the declaration. But I think what would be useful, Bryce, if you can just talk us through, there isn't a blanket moratorium on evictions, they can still happen. So what are the circumstances in which a tenant could be issued with a notice to vacate? And what should they do about it if they end up with one of these letters saying you've got to get out of the house by, June the 12th? What should they do if that happens?
Yeah, well, like you said, Sophie, there isn't a blanket ban on evictions, and some of the areas where we're still seeing eviction notices being served are around causing public nuisance, causing damage to a property, really any other breach of the tenancy agreement, all those rights and obligations that the tenants and the lessors entered into when they entered into the agreement. If there's a breach of that agreement that's serious enough, then a lessor could still serve you with a notice to vacate. Obviously, it needs to be in accordance with the law and with the agreement, but they are still being served. And it's also important to remember that the ban on evictions for rental arrears really only applies to impacted households as well. So if you aren't in an impacted household, but you've just stopped paying rent, the lessor can still issue you with a notice to vacate. And I think this goes back to what I mentioned earlier about really having open communication with your lessor or their agent about what's happening in the household if you are suffering due to COVID-19. Because if you don't relay that information, you're not really availing yourself to the protection of the declaration. You need to signal to them that the reason you're not paying is because you are impacted by COVID-19, or else they're just going to think you've stopped paying rent. So it's really important around that space. And, if someone is issued with a notice to vacate, it could be for the breach. It could also be, as I mentioned, if the lessor genuinely intends to move back into the property. It could be if they intend to do renovations. And they could even be served with a genuine general 26-week notice to vacate. Obviously, that's a pretty long time frame. But we're kind of seeing the whole gamut right now on lessors who, unfortunately, some who are also seriously struggling at this time, trying to access alternative modes of housing. Maybe they can't afford the rent in a place they're staying now, where they've been working remotely and they have to come back and try to access their housing here. We're seeing it in a variety of ways. But anytime someone is issued with a notice to vacate, the first thing they should do is call a legal service like Legal Aid or Canberra Community Law and try to get advice around how best to respond to that. It could be that the notice is completely valid and the tenant's going to have to really kind of start assessing their options. It could be that there's no validity behind the notice to vacate, and obviously a legal service can help them contest that notice to vacate and possibly even contest it in eviction proceedings as well. I'm guessing you guys are still seeing that in public housing as well.
Yeah, that's right. So just the same as in a private rental, you can be evicted from public housing for a range of reasons. Housing ACT have made a public commitment not to evict any public housing tenants due to rental arrears. That's not forbidden in law though, so it's still really important if you are accruing rental arrears, that you talk to Housing ACT and you sort out the rental rebate like we discussed before. But some of the other reasons why you could be issued with a notice to vacate would be something like if you don't take reasonable care of the property. So what that might look like in practice is if you, or maybe some people you invite over, say you have a big party and you cause, damage to the property, like holes in the wall or some sort of serious damage of that nature, that could be a ground for eviction. What they call antisocial behaviour. So again, this could be things like having lots of really loud parties at night. It could be aggressive behaviour towards neighbours, anything like that. Or if the house is being used for illegal purposes, for example. So things like drug dealing or other activities like that. And that's the same for public and private tenants. You can't do those things within the tenancy agreement. And if you do, you can be issued with a notice to vacate and be threatened with eviction. The moratorium doesn't stop any of those things. I think one thing, so Bryce said, it's important if you do get one of these legal letters that says you probably will get something called a notice to remedy first, which asks you to fix the problem. And then if you don't fix that problem within the time period, then you'll get a notice to vacate asking you to leave. It's really important that you know that there's nothing that your landlord or housing ACT can do to get you to leave your property. That's not their right. Only the tribunal, so only ACAT, which is, like a court, but it's a bit more informal. It's called a tribunal. They're the only ones who can issue an order that says you actually have to leave your property. So even if you get a letter saying you need to be out by this date from your landlord, you aren't obliged to physically leave the property by that date, but certainly it's very serious. It's a legal notification and you should seek some legal help. But only the tribunal can actually order you to leave. We've got a couple of questions. One that sort of relates directly to the reasons why people might find themselves getting into difficulty is someone has asked, what happens if my housemates stop paying rent? So if you're in a share house kind of arrangement and you're still paying rent, but your housemate isn't, what happens there? Oh, hold on, let me just unmute you.
Yeah, I mean, unfortunately, we are receiving calls like this at Legal Aid as well. Obviously, in Canberra, the market is such that there are a lot of share houses and a lot of co-tenancies. If your housemate has stopped paying rent, it'll be critical to figure out why they've stopped paying rent. If it's related to COVID-19, if they've lost their job due to COVID-19, or they've become ill themselves, or they want to go back home and take care of someone, you may be able to qualify as an impacted household. And again, then it becomes critical that you alert the lessor or their agent so they're aware of that. Due to the nature of tenancy agreements, most of them are what we call joint and several liability, wherein even though you and your co-tenant and your housemate may have an arrangement amongst yourself as to how much rent each of you pays, at the end of the day, you're both liable for the entirety of the rent. So if one co-tenant just abandons and flees the area and can't be found, your lessor could technically come after you directly for the entirety of the rent that's owed. And then it would be incumbent on you, if you would like to get that money back, to go after your co-tenant in a separate proceeding. It does get a bit complicated. And we have had some callers reach out to us trying to almost not even negotiate with their lessor, but negotiate with their housemate and try to figure out a way that they can come to an arrangement where the housemate can stay and still contribute to the rent, so that the remaining housemate is able to not lose the house over their head as well. But again, if you're abandoning co-tenant, it's due to COVID-19 related reasons. You should and could still be protected by the declaration and the moratorium on evictions for impacted households. There are some other options as well. If the tenancy is suffering and the tenant can no longer pay due to a significant hardship, there are options for tenants to apply to terminate the tenancy proactively if they feel that the tenancy just can no longer continue because of the ongoing hardship due to the abandoning co-tenant. So there are some options available, but it's good to communicate and good to reach out to a legal service as well.
Yeah, great. Thanks, Bryce. And I think largely that all applies to public housing as well, except to understand that the way that the rental rebates work with housing, that's where they understand what your income is and they charge you rent based on a percentage of that. They do that based on everyone that's in the house. They add all your incomes together and then calculate a rebated rent. So if your housemate is going through financial difficulty because something's happened to them, COVID related or not, but their financial situation has changed, you really need to encourage them to proactively contact Housing ACT and for them to update their rental rebate, because actually it's going to impact on all of you, whether or not they do that within the house. So one more question for you, Bryce. Oscar has written in saying, can you please advise what is the impact on landlords' insurance with coronavirus? I have been advised that a reduction in rent to accommodate the coronavirus impact will void landlord insurance. Are you able to comment on that, Bryce?
Not any more than someone who's probably listened to ABC News the last few weeks. We don't deal with many landlords on the tenancy advice service. When landlords do call legal aid, we try to funnel them into other services that aren't going to fall into conflict with the services that we provide. So I'm not too across the landscape with landlords insurance right now. I do know that there is some difficulty with landlords accessing their insurance schemes after offering genuine rental reductions. Although I couldn't tell you about the intricacies of that or what they could be doing in response, unfortunately.
Yeah, no worries. We'll have a bit of a look and see if we can post you something useful in the comments. But I also don't have an answer for you on that. Sorry, Oscar. Last question, unless anyone jumps in while you're commenting on this, but there's been a recent announcement around a conciliation process with landlords and tenants. Are you able to tell us a little bit about that and how people can access it and what it's meant to do?
Well, the announcement was very short on detail. It has identified the conflict resolution service as the preferred provider of this conciliation service. There hasn't been any detail around whether or not it'll be mandatory, whether it'll be free, unfortunately, even when it'll start. But it is good to see that the ACT government is taking this seriously, that it is very difficult for tenants to enter in negotiations with their landlords because of the natural power imbalance that exists. And as I mentioned earlier, the land tax rebate scheme is great, but it doesn't really push landlords into a discussion. So if there is a mechanism and some professional mediators that can help tenants and landlords navigate these discussions and hopefully come out with positive outcomes, then that's all the better. So we're excited to see where it goes, but unfortunately right now the details are pretty sparse.
Yeah, no worries. Okay, so watch that space and we'll see what happens with the conciliation. I think, so one of my colleagues has just posted in saying that she thinks Oscar's question is maybe more, what if their landlord has used the insurance as an excuse not to allow the reduction in rent? And I think that goes back to your earlier comments, Bryce, about there's no actual obligation, is there, on a landlord of a private tenancy to reduce the rent because you're experiencing financial hardship? Doesn't really matter what excuse they use.
Unfortunately, it doesn't really matter what excuse they use. In other jurisdictions, I don't know if it's the law, but there has been a lot of messaging about landlords entering into good faith negotiations. They're really strongly encouraging lessors not to just be arbitrary and give any random excuse to deny a rent reduction. They want to encourage them to really take it seriously and to put in all their efforts to see if there's any rent reduction they can offer. We haven't seen that kind of messaging here yet. We hope that it comes in some way, shape, or form, hope maybe even as part of this new conciliation service that's being offered. But we don't know exactly what that will look like at the end of the day.
Yeah, no worries. Great. Thanks, Bryce. So that's all the questions I think that we've come through, and we've been chatting to you guys for almost 45 minutes now. So I think we'll wrap, but just to clarify, well, not to clarify, just to sum up some of the key points coming out of this, there have been some changes because of COVID-19 and the financial stress that so many people are under. But those changes afford some limited protections to people. So Bryce talked to us about what happens if you're an impacted household. So there's certain criteria that are spelled out in the declaration that means your landlord can't evict you because of rental arrears during the 3-month period that the ACT government has declared there's this moratorium. That's only until July 22nd. But if you think that you could be an impacted household, so you've recently gone on to JobSeeker, you've experienced a drop of in your income due to COVID-19, and you do receive a notice to vacate, then definitely contact legal aid and have a conversation about whether it's possible that you are protected by the moratorium and shouldn't be evicted during this time. For public housing tenants, there have been some verbal confirmations from ACT Housing saying that they won't evict anyone during this time. But again, same as for everybody, there are no absolute guarantees. So what's really important with public housing tenants is that you talk to Housing ACT and fill in a rental rebate form if your circumstances change. And similarly, as Bryce encouraged, if you're a private tenant and you're experiencing difficulty, it's also important to be upfront with your landlord so that you can enter into some negotiations about a rental reduction. But unfortunately, there are no guarantees and no obligations for your landlord to give them that reduction to you. The other changes that we touched on were things like repairs. So you still have a right to have urgent repairs carried out as soon as is necessary in your property. So that's things like a broken toilet, a door or a window that goes into the outside world that could provide a safety or security risk to you, electricity or gas failures. These things, it's still the landlord's obligation to repair any damage of that nature urgently. With standard repairs though, that's changed a bit because of COVID-19. And so now there's some more flexibility for the landlord and the tenant to negotiate what's a reasonable time period for those repairs to take place. If you're having trouble with repairs, getting them done or getting them done properly, you can contact legal aid. If you're a private tenant, or Canberra Community Law if you're a public housing tenant, and we can help you go through the process of trying to get that rectified. The other thing we touched on was house inspections. So again, same situation for public and private tenants. During this period that the declaration applies to, so that's until the 22nd of July, your landlord can't insist that they conduct a in-person inspection of your house. However, you do have to cooperate with them to help them conduct an inspection if they're entitled to. So they're allowed 2 per year. If it's one of those ones, they can do it, using FaceTime or a phone, or get you to send in photos. And so long as it's reasonable, you need to cooperate with that. But they can't just come barging into your house because of the sort of public health implications of that. Sorry, and the final thing that we touched on was that there are still non-rental arrear reasons why you can be evicted. So same as pre-COVID-19 times. If you're doing things like illegal activity at your house, or you cause big damage to your property, there are still these other reasons why you can be evicted. And so if you do get a notice to vacate, that legal letter that we talked about saying you need to leave the house by this date, remember that no one can make you leave the house except for the tribunal, but you absolutely should seek legal advice as soon as possible because that is a serious legal threat, and it's important that you take it seriously and get some help as soon as possible. So you can contact legal aid if it's a private tenancy, or Canberra Community Law if it's a public tenancy. So I think that is everything. I'm just checking that we have no more questions. I can see that Canberra Community Law has posted a bunch of links in the comments, including the contact details to our organisations. We'll do our best to follow up for you, Oscar, with your question. And if there are any other questions over the coming days, we'll keep an eye out and answer them. Thanks so much, Bryce, for giving up your time to come and do this Q&A with us.
Well, thank you, Sophie. It's been a pleasure.
Great. All right, talk to you all soon. If anyone in the comments, if you have any ideas about other Q&As that you would like us to run, please also comment them. And we're doing a few more about coronavirus and how it impacts on your legal rights in the coming weeks. Okay, thanks everyone. Bye.